is if that will be loaded. Downloaded what? Okay. Oh. You can sign for it. It's all set up.
I have some upstairs. Can you pull this one?
Hey, looks like a full house tonight.
Oh, hi, Joe.
Hey,
Here's your,
hello, Gary.
has that, yeah, thanks.
Loading?
Here's some reading material for you.
Oh, yeah. We've got a full docket tonight, full house with full docket.
Yeah, I'm all set. Yeah, I know, everything switched over. Yeah, I think I'm good.
Yeah, I'll talk about that.
Sure.
Call the meeting to order, the pledge of allegiance to the flag.
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Keith Johnson? Ralph Reese?
Here.
Joe Michael?
Here.
Gary Guglielmetti?
Here.
Mark Lody?
Here.
Did everyone get a chance to look at the minutes from last month? We got a motion. Motion to accept the minutes.
Someone read them?
Make a motion to accept this type.
I'll second that. Get a little. Joe, have you read the minutes?
Yes, I have.
Okay.
Need a vote on that motion to accept?
No, just all in favor?
Aye.
Aye.
everybody understands the packets that are there, right? I did send out an email, or quite a few emails earlier today. Okay. So just everything relevant to the matter since the area variance application submitted May 21st of last year. I'm sorry, April 21st of last year. Okay.
Call Mr. Higley. Is there any other business?
Good evening. For those of you that I haven't met, Philip Wellner on behalf of Hanover Farms, Mr. Higley, sitting here. I believe at the last meeting, we came asking that the application of Hanover Farms be restored to the calendar, at least for the purpose of coming here today to ask the board to formally consider restoring the application to consideration of the board. In looking back over my comments from the last meeting, I was referring to a letter, which is the most recent communication my client had from the DOT regarding what information, if any, they were looking for. My understanding from the minutes and from reviewing the October 15th meeting of this board from last year, that the basis for denying Hanover Farms' application was incomplete information that was furnished to the DOT. I brought with me copies of the most recent correspondence that my clients have from the DOT. If I may distribute them to the board, there's no objection. Sure. I was under the impression that the board had copies of this letter, but just in case that's not the case, I know that there was a letter that was in the board's file that was mentioned in discussions about the application both back in October and also at the last meeting that predates this letter. My client's understanding from this letter is that the DOT wasn't waiting for any information from Hanover Farms. It was waiting for this board to decide whether it was going to grant a variance or not, at which point the DOT could proceed. So my request last time, and I'll formally make the request today, is that it appears that the basis for denying the application in October of last year was just based on a mistaken understanding of what the DOT, if anything, was looking for. So I provided the letter, and again, I would ask that the application be restored to consideration so that whatever information the DOT needs after this board makes its decision, we're certainly willing to provide that. If there's any other information that wasn't discussed at the October meeting that's still required, Hanover Farms is certainly willing to provide that. But again, the basis for the request is just, it appears there was a misunderstanding in October at that meeting when the matter was voted on.
Well, I don't think that there was a misunderstanding of the quote, but also we had a referral from the county basically creating a situation where we couldn't, without a supermajority, override the county's recommendation. That letter's in here somewhere also. So I don't think that the basis for the decision was based on the fact that we didn't get the information that we requested earlier on. Was the chairman at that point in time, he had asked for specific information from DOT. And I realized it was a catch-22 situation because of the fact that they couldn't complete a site plan until the variances were granted. The variances, according to the county, we weren't allowed to grant the variances unless DOT had made some formal statement as to exactly what they wanted. So basically what the letter from DOT did was put it back in our lap. The county basically said you can't do it without the safety issue being resolved with the egress regress.
And I apologize, the recommendation from the planning board, the Ulster County Planning Board, at least the document that they provided to me was phrased in terms of recommendation. It wasn't a directive, but I may be looking at a different document that the board was looking at. When I contacted the Ulster County Planning Board, I asked them for whatever recommendation they had made regarding Hanover Farms, and it was, the language of it was absolutely a recommendation, not a mandate. So my understanding of that was they couldn't and they weren't trying to tell this board what to do.
That's not correct. I don't know what letter they gave you. The letter we received, there was something here called a required modification. Required modification under the rules of the Ulster County Planning Department requires is a binding requirement, and you can only overrule it by a majority plus one supermajority vote. So it wasn't just merely a recommendation.
That sounds like a different document than what you provided.
Right. Well, the date of the document we're referring to is May 7th. The review date was May 7th of 14. So it's well within, the decision wasn't made till when, October, I believe?
October 15th.
October 15th. So this was, you may have been misled by the way they title it. They title their documents recommendations, but if you look at the body of the document, there's a section there called recommendations, and after that there's a section called required modifications. It's under the required modification where the language was about the ZBA and the DOT and the planning board all needing to work together to make sure that this was a safe environment. And so the applicant not having brought proof before the board prior to a decision that in fact was the case, the board had no other choice but to make a finding that under the ZBA criteria that the benefit to the applicant was outweighed by the detriment to the community. And that, that was issued in October of 14, so a long time ago already.
Understood. That language is not language that I recognize from what was provided to me by the Ulster County Planning Board. Is there a copy of that I could either take a look at? Or?
Here, it's this section.
That's the original recommendation, and the first and only one that was ever received from the planning board regarding this application.
So there was a time period, just so everyone, to refresh everyone's recollection, there was a time period from May through October when there was the opportunity to address that, and it had not been addressed.
I guess my response to reading this language is, with all due respect to the Ulster County Planning Board and the DOT, those two bodies seem to have put not only this board into a catch-22, but my clients into a catch-22. Whether my clients understood that and whether the DOT understood that catch-22 existed, I still renew my request that this be restored to the calendar. Because this was denied for lack of sufficient submissions by Hanover Farms, if the board insists on my clients file a new application, they're willing to do that. We'll pay the $100 and we'll file a new application this week and bring it back before the board. This was not a denial on the merits, it was a denial for lack of information. And now that we're aware that this catch-22 exists, we can certainly try and remedy that with the DOT and the Ulster County Planning Board. But having said that, I would ask the board not require my clients to jump through that additional hoop when I think, as the chairman himself recognized, this is a catch-22 not of your making, not of my client's making, but of the DOT and the Ulster County Planning Board's making. And maybe the issue was simply a lack of understanding of how to break that catch-22, because procedurally, as a board, I'm sure you don't want applicants caught up in a no-win situation like that. And with all due respect to the amount of time that's passed, there's no time limit on renewing an application if it's been denied because there isn't sufficient information. So again, I would ask the board in the spirit of cooperation, we're not talking about time limits on appeal, and we're not talking about challenging decisions of this board. We're talking about trying to do the right thing and move an application forward on its merits.
If you need our permission to reapply.
Do you want to keep this? You can keep this if you
Oh,
want.
thank you.
Sure.
Okay, I have a question. There was an adequate 90-day period to apply for an Article 78. Article 38.
No.
30 days.
30 days. Okay, sorry. For the Article 78,
Yes.
which was not taken advantage of. Can we ask why?
Well,
It was appropriate time to do this.
I guess there are a couple things. First of all, my clients were looking for new counsel to work with them through the process. I wasn't hired until after that, well after that 30 days was expired. But I think the bigger point here is, an appeal is, it's, in my view, an appeal is not a cooperative way to go forward, especially when you're talking about a denial, not on the merits. I mean, this board never said, we've received all the information that's necessary from Hanover Farms, and we don't think that this application should be granted for substantive reasons. It was a denial because there simply wasn't enough information. To go to the cost and the expense of an Article 78 to challenge the board's decision on lack of sufficient paperwork when my clients could just come back and either refile or ask the board to reconsider its decision, it seems like an unnecessary waste of the court's time and of my client's money. And we would still end up back in front of this board, and frankly, why litigate against the board instead of trying to come back here and complete the application in a cooperative way?
Well, is that suggesting that the improvements being asked for and the documentation being asked for that was not provided because of this alleged misunderstanding, in fact, existed to be submitted at the time?
Well, they had to be, I think the catch-22 that the chairman was referring to is that there was a site plan that had to be developed, the Ulster County Planning Board was looking for, the DOT said, we can't work on developing this until the board grants the variance. Now, what we may have to do is go back to the DOT and explain to them that the Ulster County Planning Board has tied the hands of the board. You can't make your decision on the variance until that site plan is developed, so please reconsider your position that you can't do any more work on this until the variance is granted. But I think that's procedurally the way to move forward. The documentation doesn't exist because it couldn't exist without the DOT's changing the position in the letter that I provided to the board.
I just want to comment that when an applicant makes an application to a board, particularly a zoning board of appeals, the applicant has the burden of getting the information to the board in advance of the board making its decision. It's kind of disingenuous to have a situation where at one point in time you had a letter that came out in May. We waited until October. Nothing was done to provide the information, and it was not a situation where the applicant and his representatives were not reminded that we needed that information. We had a letter that essentially told us that there's a potential unsafe situation out there. We had no independent information from anybody, not just the DOT, but there was no traffic expert provided. There was nothing in the record that was submitted to us as of that time that allowed the board to come to a conclusion that would operate in an acceptable and safe manner. The idea was, during the time that we received that letter, is for these guys to have to go to DOT, work out whatever they needed to work out with the DOT, hiring whatever experts they needed to do that, and come back to us with information from the DOT that would basically say, yeah, this is a configuration that now can safely work out there. We never had that information. So we were unable to act in a positive manner. And I think if you go back and read the decision, that's the essence of the decision. To come back now 7 or 8 months later and basically say, oh, we're willing to do that now is not really a permissible way to proceed, under the law. I mean, it would be much better much better to come back here having already done something like that, for example, and say, oh, we've hired an expert, we've been to the DOT, it's all worked out, this is a safe situation, and then entertain possibly, a revised application based on changed circumstances, something like that.
Well, aside from being reasonable, is this motion legal?
Well, there's no, restoring an application, there's no obligation on your part to restore an application previously heard to your agenda, okay? It's not like someone can come back in and submit the same application very next day after you've taken an action on it. There's a procedure in the town law to rehear an application, okay? And I've given you an opinion on that, and that procedure essentially says that if there's a motion by a zoning board member to rehear the application, and presumably that zoning board member would have a reason for that, not just because it wants to rehear it, but if there is a motion to that effect, and then every member of the zoning board of appeals agrees to rehear it, it can be reheard. Okay, so that's essentially the procedure. Absent that, I think it really is something that has to come back to the board of that would demonstrate substantial new facts and circumstances such that a new application could be submitted. Maybe they've decided to change the configuration. Maybe there's a way to eliminate all the variances needed, so they don't even have to come back to the ZBA. Maybe there's maybe there's some reconfiguration of the area. Maybe they come back having done what they need to do with the DOT and are able to demonstrate that this thing can operate in a safe manner. None of that has happened to this time. So I think that, I don't think that there's any legal basis to force you to rehear this unless you guys just simply unanimously determine that you want to.
I think if I may make a couple of points. First of all, I'm certainly not asking, I'm not trying to force you to rehear it. This is a request from my client being made to the town board, to the ZBA. So it's a request that it be reheard. I'm in response to Mr. Lewinsky's point about changed circumstances. If there's something in either town law or state law that says that when an application is denied because it's not complete, and then the applicant comes back and resubmits it, that not only does it have to be complete, but there has to be some changed circumstances from that first time. There's something in state law or town law that says that. I'm not aware of it. I'd be very interested to see that. The changed circumstances is not something that has to be shown to this board. If you deny an application on the merits, then that might be different. But if you deny an application simply because all of the required pieces of the puzzle have not been presented to this board, if my client comes back and resubmits the application and has all those pieces, there's nothing to prevent this board from hearing that application, and it should hear that application. The question here is, again, I understand that time passed. I understand that maybe the reason time passed was because of things that had nothing to do with the application, maybe a search for new counsel, maybe some other things. But the situation that existed, whether it was in May or July of last year, was the DOT was saying we don't have to and won't do anything. And the Ulster County Planning Board was, until this board acts, the Ulster County Planning Board was saying the board can't act until the DOT does something. Now, with all due respect to both of those agencies, I'm not sure it would have been a simple thing for my clients to go back and simply force the DOT to take some action, but notwithstanding that, that's what we'll try to do now. But as I said, the reason that I'm asking this board to consider reopening the application is simply because this catch-22 was not of my client's making, and the fact that solving that catch-22 wasn't done in the snap of the fingers and couldn't be done in the snap of the fingers isn't a reason to throw them out the door and make them start over again.
6 months is not a snap of the fingers.
I understand that. I understand that. But at the same time, given that Hanover Farms could come in and file a new application And with the proper documentation, there would be no reason to deny that application simply because it's the second attempt to get a variance. Again, I would ask that the board not set the clock back and take more of this board's time going back to the very starting line and allow us to go directly to the next step in the process, which is resolving the catch-22 that the chairman described.
I'd like to just refresh your recollection about two items in the decision. Okay? These were findings of fact made by the board. It said, number 15, it said, in light of the county referral response, the applicant no later than May 2014 was directed by the ZBA to seek input from the DOT as to the vehicular and pedestrian traffic safety issues presented by its site plan and associated request for variances. The next finding was DOT has advised the ZBA that the applicant has been informed of what it needs to provide it in order for the NYSDOT to conduct a review of the applicant's plan, but has never received that information from the applicant. Okay, that was what we had to go on. As I pointed out, this isn't an issue of an incomplete, merely an incomplete information. This is an applicant who was given an opportunity to meet its burden of proof and either, for whatever reason, didn't do that. The board did not have the substantial evidence before it to make the determination it needed to issue those variances that were requested. So that's the way it came down, and that's, I think, a fair, objective, and accurate way to depict that.
And members of the board, this is exactly the misunderstanding that I was referring to when I first stood up here today. The May letter the May direction to my clients to determine what the DOT needed, whatever the DOT said to this board, and I don't have a copy of that letter, but whatever the DOT said to that board, my clients did in fact contact the DOT to ask what is needed from them. And the letter that I've given you, which from what I remember from last month's meeting, from discussion about that, whatever letter the DOT sent to this board, the letter that I provided you here today came after that and told my clients, we don't need anything from you because the next step is for the ZBA to act. So my clients did what was asked of them, and that's the misunderstanding in the record, and that finding of fact is the one that I think is incorrect because, again, my clients contacted the DOT and they were told, you need to get a decision from the ZBA and then we'll proceed.
The letter is not in this package.
Well, this letter wasn't direct. First of all, this letter was not directed to the ZBA. We did have it before us at the time of the decision, but I think, as for the record, we ought to note that the letter was directed to Don Brewer. Okay.
Are you referring to the Daniel Corrigan, David Corrigan letter?
Yeah, the David.
July 29th.
Yeah.
Yeah.
And I believe at that time, Mr. Brewer was representing the applicant. Okay. Also, I had personally had a conversation with DOT, which I'm willing to put into an affidavit if necessary. Very close to the time we were about to make the decision, Tom Hickey also did. We were told that the DOT had received nothing. We were told that the DOT would advise the applicants at the time what it needed to submit to the DOT in order to get this resolved through a highway permit application or a plan. The DOT was very clear on what it was that was needed. The DOT said it didn't have the information before it that it was able to, help out on that. Okay, and that happened way after July 29th. Those communications probably occurred in September of 14, when we were getting toward the decision point on the application. So,
I don't see anything in the documentation before us that would indicate any other different outcome if the procedure were reapplied. Does anybody else on this board see any difference? So I'd like to ask Mr. Wellner, is Mr. Higley suggesting that he has some facts or some physical improvements that would affect the outcome of the reapplication?
Well, no,
And if so, what are they?
It's not, what we're coming here today is not to say we've solved the problem, but rather to say, you know, any application process is a process that takes time. It's an iterative process. The first time that an applicant comes in front of the board